Hello and welcome to this Lexology webinar. My name is Simon Tyree. I'm an editor here at Lexology and I'd like to thank you all for tuning in. We have a really great presentation lined up for you today discussing the privacy, data protection and cybersecurity considerations that employers have to consider in the age of COVID-19. There are just a few general admin points to mention before we start. First, please use the online question tool to post any questions you have and they will be posed to our speakers after the presentation. Second, if you have any audio-visual problems during the presentation, please let us know by using the online question tool and we will do our best to resolve them. And finally, just to note, the recording of this session and the accompanying slides will be posted online and we will send a link to all webinar attendees. Please use the link and send it to any colleagues who you think may be interested in today's presentation. So without further ado, I'd like to hand over to Martin, Jenny and Caitlin.
Thank you, Simon, and hi, everyone. Thank you for joining us for this session. My name is Marty Zoltik. I'm a technology lawyer with the Rothwell Figg law firm, which is based in Washington, D.C. I've been practicing for about 30 years now. My practice is primarily focused on intellectual property, transactions, privacy, data protection, and cybersecurity. I have a degree in computer science. Prior to law school, I worked as a software engineer focusing on networking and artificial intelligence. From a technology standpoint, much of my practice focuses on software, internet, telecom, big data, and AI. I'm very excited to be here to talk with you about what I think is a very timely and important topic in a very fast evolving area of the law. And I'm going to have Jenny and Caitlin introduce themselves as well.
Thanks, Marty. My name is Jenny Colgate, and I am also a partner at Rothwell Figg. We have about 40 to 45 lawyers in our practice, and I, like Marty, practice intellectual property law, litigation mostly, patents, trade secrets, copyright, trademark, unfair competition, privacy, data protection, cybersecurity. My undergraduate degree is from the University of Pennsylvania in communications, and I actually did a thesis in the area of children and privacy. So I'll turn it over to Caitlin.
Thanks, Jenny. My name is Caitlin Wilmot. I'm an associate at Rothwell Figg here in DC. I have a background in chemical engineering, and then I was also a patent examiner at the U.S. Patent and Trademark Office for a few years in the field of batteries and fuel cells. Here at the firm, I do patent litigation, a little bit of prosecutions and trademarks, and of course, I'm on our privacy and data security team as well. So I will pass it back to Marty to get us started.
Okay, if you can just bring up the agenda. So the goal of the session today is to highlight for all of you what we've identified as important privacy, data protection, and cybersecurity considerations that employers really need to evaluate in an environment, or I should say in a world that essentially changed for all of us overnight, where employers were essentially forced to come up with new or different policies and procedures for their businesses and their employees very quickly, and in what really is an uncharted situation. So the agenda for the session, the first part's up on the screen. There's another slide as well. We're going to tick through each of the topics, and then, as Simon said, we're going to leave time for some questions at the end. If you can go to the next slide, yeah. So there are lots of reasons why today addressing privacy, data protection, and cybersecurity issues is important. It's important for your business, it's important for your clients' businesses, and it's actually important for us as individuals. One thing that the COVID-19 pandemic has done is really elevated these issues. And if you look at the graphic on the slide, I think it sort of brings to light the importance in the current environment, indicating that 42% of the U.S. workers are now working from home. And what also struck me is that, if you can go back, yeah, what also struck me is that that represented, according to the study, more than 2/3 of U.S. economic activity. So important. And with that, all the people working from home, that large of a percentage, obviously there are vast amounts of data, including personal data, including business information, client data that is being generated and collected and transmitted and processed, in a volume that is much greater than before the pandemic, and clearly, taking what was perhaps working in an office environment or in a secure facility to people, many people working from home is going to create challenges as far as security, privacy, and data protection. It's challenged us. It's as a society. It's challenged us in how we work and changing the way that we work. And while it appears at some point, hopefully, and you can't look too far into the crystal ball, that we're going to go back to some form of what we had before, it's clear that work from home, there's still going to be work from home, and there's going to be more of a hybrid situation. At least that's the way it looks. So business leaders and policymakers and so on are going to have to deal with this issue and think about it in a more long-term basis. So if you can go to the next slide. Another very apparent reason why addressing privacy, data protection, cybersecurity is paramount is the rise in the number of high-profile data breaches. I periodically look at this website, which is listed here, that updates very regularly. We hear about these major data breaches, but I'm always struck by, the total number of data breaches that may be smaller than the major ones we hear about, but that, of course, if it affects you or your clients or your company's information, doesn't matter how large the data breach is, it still has the same impact. What this has done is create an environment where there's a real lack of trust. As a result of that, it's driving, governments and policymakers and public and private sector businesses to focus on the area. And with that focus has come more comprehensive privacy and data protection regulations. So with that, before we jump into the specifics of privacy and security and the applicable rules and laws and regulations, we wanted to put some context around the specific data and specific information we're talking about and the rights and protections regarding that data and that information. So what is privacy? When we think of privacy generally, it's the right to be let alone. When we think about privacy in this context, we're really talking about information privacy, the appropriate use of personal information under particular circumstances. And when we think about that issue of information privacy, we think about it from the individual standpoint as the right to determine how that individual's information, we'll get into some definitions of personally identifiable information, PII, but how that information is being used. And we look at it from the standpoint of, or we think about it from the standpoint of the individual's right to control the collection or the use or the processing, the storage, disclosure, sale, retention, or deletion of that information. We consider providing notice to the individual, giving the individual a choice, opting in, opting out, and then ultimately limiting how that information, or limiting that information from becoming publicly available. If you go to the next slide. And we move from information privacy and think about the data and data protection, and I always think about this less from the individual standpoint and more from the organization standpoint. We think about what systems are in place to handle, store, and manage the personal information that's being collected or processed or transmitted. What kind of controls are in place with respect to that information from a security standpoint to make sure that it's secure, and from a quality standpoint to make sure that it's up to date, kept up to date and accurate. We think about that information through the whole life cycle, from initially when it's collected through the process until the end when it may be ultimately deleted or destroyed. And then lastly, what kind of management tools are in place to deal with the administration of that data, the management of that data, monitoring for things like breaches, and ultimately if there's any enforcement that needs to take place. You can go to the next slide. So here is some information on what's considered PII, personally identifiable information. It's different depending on relevant statutes, you know, of course the GDPR, of course the CCPA, but we have other definitions within the US, for example, that are provided through the government agencies that deal with privacy, like HIPAA, Health and Human Services. But in general, what is threaded all throughout those definitions is really it's information which can be used to distinguish or trace an individual's identity, like a name, like a social security number, like biometric records. And of course, there are individual pieces of information that alone may not identify an individual, but then when combined with others, will provide information that would identify the individual when those are linked up, like date of birth or place of birth or mother's maiden name. We included the GDPR definition here. It's again very broad and also includes some additional specifics about what is considered personal data under the GDPR, like location data, like online identifiers, and so on. So we can go to the next slide. We contrast PII with what isn't PII, non-personal information, de-identified, anonymized, or aggregated data. There's a lot of debate still that is ongoing about, you know, how if you aggregate or if you de-identify or anonymize, you know, does it really take personal information and create it in such a way that you wouldn't be able to identify the individual? So that's a little bit of a gray area. There's certainly a lot of companies that are working on algorithms to try and take what is PII and turn it into non-personal information. We also included pseudonymized data, which really is sort of pulling apart the identifier of the individual with the data and creating a way to link it back up with a token or something else like that. That's not fully anonymized. We think about this because when you're trying to advise a client about the information they're collecting and whether it really falls within some of these laws, well, is it personal information? And if it, what can you do to sort of take it out of that realm and still make it be useful? You can go to the next slide. A subset of PII that is subject to more restrictions than others is what would generally be referred to as sensitive personal information, requiring additional privacy and security limitations, things like passport numbers, social security numbers, tax ID, financial and health data. The one thing I always point out here is, you know, with those types, that type of information, passport numbers, social security numbers, if it's taken, disclosed, you can change it and get a new one. Things like genetic data and biometric data, at least currently, that's all you got. You can't change that. So we really need to be incredibly careful with that type of information. So just at a high level, to think about the privacy law and regulation landscape around the world, and to talk about how it's sort of categorized and then go down to the US. There are a growing number of countries that have comprehensive privacy laws, like the EU with the GDPR, like Brazil, India, and Japan as examples. In the US, currently we don't have that. We have what we always refer to as a patchwork system. At the federal level and at the state level, we have no comprehensive federal law. We have a number of federal agencies that deal with privacy issues in a sort of sectoral way. The FTC is really the major government agency that deals with privacy-related issues, but others that are listed here, for example, have privacy statutes that are more specific to the type of information that companies operating within that sector would collect. And then I'm going to go into it a little further, but we have states who now, like California with the CCPA, and other states that have their own laws in place that are enforced by attorneys general, and for some, there's some private rights of action. If you go to the next slide, this is intended to just give a little, kind of a current state of affairs with respect to the state privacy laws. The IAPP has what I think is a really helpful and updated map with a corresponding table that talks about what's going on in the different states. And currently, I mean, I use the word comprehensive privacy law a little loosely because some of them are not as comprehensive as the CCPA, but California, Nevada, and Maine have adopted what fall into the category of general privacy statutes. And then you can see through the colors there are a number of other states that are in varying degrees of proposed legislation being considered, and but not introduced, but not passed or signed into law at this point. There also is a lot of activity at the state level with respect to industry-specific privacy laws. I said before, my background's in telecom. I do a lot of work in that area, Internet of Things. There's in California, along with CCPA, they had the Security of Connected Devices law. Other states are following. There's specific laws regarding ISPs now in different states, healthcare, biometric, financial, children, and so on. States also have general privacy laws that deal with things like breach notification and privacy policies and taking reasonable security measures. And then we also wanted to point out the unfair or deceptive acts or practices state laws that are also being used to deal with privacy issues and privacy breaches. Just to mention, in fact, started an hour and 20 minutes ago on the Hill, a session committee meeting to talk about a federal general privacy law in the United States. It's ongoing right now with 3 former FTC commissioners, so we'll see what happens. What they indicated in the note is what's partly driving this is what's going on with COVID and with the collection of personal information associated with that and consumer concerns about it. And so, this may kickstart what started before, but really I think, is more under the microscope now, getting us in the US some federal laws relating to privacy. I already previously mentioned the FTC and the state UDAP actions that are being used to deal with these issues. There were also 2 bills introduced a few months ago dealing with COVID-related privacy and sort of trying to limit how that information would be used, giving a private right of action. There were 2 competing bills, and from checking recently, they're both just sort of sitting. They've been introduced, but there hasn't been any activity associated with them. I mentioned the federal privacy laws previously that are under the guise of the different federal agencies, and then we've already talked about the state privacy laws that may be applicable. So with that, I'm going to turn it over to Caitlin.
Thanks, Marty. Okay, so what are these technologies that people are using to work remotely, and what are the privacy and data security considerations that go along with them? So now a lot of employers, especially now that many are working from home remotely, are employing software that tracks employee activities. So this might be to make sure that your employees are still being productive while working from home, make sure they're not spending too much time on social media or doing anything that might fall outside the scope of their employment. Of course, at this point, I'm sure we're all used to and familiar with the video conferencing tools. We use these pretty much on a daily basis in my firm, Zoom, Microsoft Teams, all different versions of the tools there. And then, of course, the use of internal chat programs so that employees are able to just send quick messages back and forth without picking up the phone or using email. So there are many ways that you are able to track and monitor your employees and different goals for doing that, tracking keystrokes, seeing which applications they used, that might be helpful to see how many employees are logging into the tools and resources that your company subscribes to, and how you might want to, if you want to cancel or update any of those subscriptions, seeing how much time employees are spending on each task, and then taking screenshots. That's another option every 10-15 minutes to see just exactly what employees are doing and what they're looking at. There was a study in 2018 that surveyed that approximately 80% of companies by this year would be engaged in some type of employee monitoring, which was an increase from 2013. And our guess is that this may have increased actually just over this summer, given COVID and the large number of employees who are now working from home. But in general, we want to point out that employees do not have a right to privacy when they're in the workplace. And this is aside from physical surveillance. So of course you have a right to privacy where you have a reasonable expectation of a private activity like using the restroom or a changing room, locker room. But especially when you're using employee or company devices, or even logging into your company networks using your own personal devices, that right to privacy does have its limitations. So at this point, we would like to do a quick poll of the audience just to see how many people work for a company that does engage in employee monitoring. So I'm going to try to not kick us out, and I will go ahead and launch this poll just to see if that is consistent with our with that Gartner statistic. I'll give us about 15-20 seconds here. Okay, so I'll go ahead and close that poll just to keep us moving. Whoops. So if you couldn't see the results from that poll, I can share the results. So we have 18% who said yes, 56%, and we have about 150 participants at that point, 26% who say they don't know. So very interesting. It seems like most of you have very trusting employers, which is good to know. Okay, so how does the CCPA or the new California privacy law play into tracking employees and working from home? Under the CCPA, you are required to have a privacy policy and give notice to your employees at the point of collection or right before of exactly what data you're collecting on them and what you're doing with it. So these notices require that you spell out exactly what data you're collecting, why you're using it, also to give a link to the company's privacy policy. And then this is unique to the CCPA, but you do need to have a link displayed for do not sell my personal information. So if your company is for some reason selling information about how they monitor their employees, or giving that to a survey or a certain platform, you do have the option, or you may have the option to opt out of that. So general best practices for complying with the CCPA and just kind of in general, know why you're monitoring your employees. You should always have kind of a legitimate business purpose for doing this type of tracking. And that can be just as simple as seeing if employees are still being productive working from home, protecting against insider threats, and seeing what platforms and tools your employees are using, as I mentioned before. And it's a good idea to actually document that business purpose or why you're monitoring, and set that forth in your privacy policy. Make a plan for data management. So you'll definitely want to employ some administrative, technical, and physical safeguards for protecting any of this information that you're collecting on your employees, and storing it securely, making sure that it's destroyed in a timely manner. And then you also want to make sure that you're communicating all of this with your employees. Nobody likes to feel like they're working with their big brother, someone's looking over their shoulder. So it's always a good idea to engage employees in this process and tell them exactly what you're doing with the data that you're collecting on them. And you might want to have training sessions just to let employees know and kind of get some feedback from them and address any concerns that they might have about being monitored. So just earlier this year, which was very timely, the FTC came out with 10 tips for just being secure and smart about how you're using video conferencing tools. So taking steps to ensure that only invited participants are joining the webinars. So just preventing any hackers or invaders for coming in and posting obscene content or inappropriately sharing their screen or different information. And ways to do that are, setting up passwords for the meetings, having the host allow people in and, from a waiting room. And you can also limit, who is able to speak, who can share their screen. Also very important, as soon as you sign on to video conferencing tools, just to make sure, is this session being recorded? Am I on mute? Is my video camera on? I'm sure we've all heard horror stories at this point of, people being inappropriately or inadequately dressed, saying something, not knowing that their microphone is on that they would not have shared normally. So just being smart and cautious about what you're sharing when you're signing on to these meetings. And just if you are sharing your screen, just making sure that you have no private information that you're sharing as well, especially if you're using a personal device to conduct work from home. And the next 5 here are really just keeping your software up to date, making sure that you're abiding by your company's kind of policies for conducting video conferencing, the do's and don'ts. And at the end of the day, if you are communicating information that is truly confidential, where confidentiality is key, then it may not be the best idea to use video conferencing at all, and you may want to take that offline on a phone call or in person or another secure medium. I know many companies now are actually asking that they don't use Zoom, just because there have been some bugs, there have been some Zoom bombing. So if it's truly confidential, maybe just not best to do it via video conferencing. And then with chat programs, again, companies just want to limit who has administrative access to these chat accounts. So don't allow third parties to have access. Again, you want to be very transparent with your employees. Let them know who's reading these chats. Are these chats stored, and what are employees allowed to talk about in these chats? Just setting up kind of like a do's and don'ts, again, of what to do and what not to do when you're using these internal communications with your colleagues here. Okay, and I will pass it back to Marty, actually, to talk about corporate policies.
Thanks, Caitlin. So we're just going to spend a few minutes talking about corporate policies and practices to try and help ensure network security. If you can go to the next slide. So just to say, we talked about some of the laws that apply and so on, but in the end, at least from what I glean, a lot of it is about reasonable security measures. If you can show that you're providing reasonable security measures, you will likely be inside and in compliance with a lot of the laws, rules, and regulations that apply to personal information. So here are some considerations to help show that your organization is using and implementing reasonable security measures. So creating and having employees sign a cybersecurity policy. And what we mean by a cybersecurity policy is really things like use of email encryption requirements, limiting use of social media, or at least putting a guide around how social media can be used, passwords, and what the requirements need to be associated with that, how you can use or install on work-related or non-work-related apps. This sort of comes to mind with thinking about the recent events with TikTok and how employers have dealt with that type of app being on a device that's maybe a company phone, smartphone, that is a mix of personal and company information, and then restricting the use of work devices and software. We wanted to get a sense of how many of y'all out there, your organization has a cybersecurity policy. So I think Caitlin is going to bring up another one of the poll questions. So we'll just wait a little bit for you all to fill it out.
Yep, we'll close it out in about 10 seconds here.
Okay. All right, so 2/3, more than 2/3. That's great. That's excellent. So some additional tools to use for best practices and trying to, you can go back, trying to ensure reasonable security measures, using secure platforms for conducting employment-related work, like a virtual private network, using two-factor, multi-factor authentication, using encryption software for transferring files, perhaps for email as well, antivirus software, malware software, firewalls. I think one of the tricks with that is making sure it's up to date. We've seen some instances of breaches where the company was doing, had a firewall or had the antivirus software, but it wasn't up to date to deal with the particular virus. Conducting regular phishing awareness training, I'm always amazed at how effective that is, especially across larger organizations. So I would encourage that. And then lastly, just considering cybersecurity insurance. We have seen a real uptick in ransomware issues targeting different industries, law firms and others, hospitals and so on. And so making sure cybersecurity insurance is in place can be, a comfort in connection with that. You can go to the next slide.
Just to chime in real quickly on the cybersecurity policy, I think something that's important for organizations to keep in mind is just because you have a policy doesn't mean it's a one and done deal. It's something that you should continually reevaluate, particularly as organizations continue to have work from home policies. There's a lot of technical development going on in the area. And so new technologies might become available that you want to, mention or restrict in the cybersecurity policy. So it should be something that's on your calendar to regularly reevaluate.
It's a great point. The next section is really just to talk about contracts with software and other vendors and what to kind of think about. There's a lot of, with the work from home environment and many organizations perhaps not really having dealt with that in the past, there are vendors that we are now dealing with that we had not dealt with before. So if you can go to the next slide. So just some things to think about relative to entering into these new contracts with software and other vendors and thinking about privacy issues. So things like who will process the data, what specific data will be processed, when will the data be processed, where will it be processed, is it really something, why will it be processed, is it really something that needs to be collected and processed, and how will the data be processed. So really taking a hard look at thinking about the data and then taking a hard look at the contract terms is very important. Thinking about if that type of data is going to need to be collected and processed in some way, what laws and regulations and standards are applicable to it. We've been using in our role of reviewing those kinds of contracts, putting in reps and warranties that limit the use of that information, personal information, and requiring conformance with legal and regulatory requirements. I mean, it's not perfect, but if you have an issue, then at least you have something to point back to help limit any liability on your end where you're trusting a third-party software or other vendor with that type of information. And again, showing reasonable security measures. Looking at the contract and whether the vendors are required to communicate changes in their own privacy and cybersecurity practices. and ensuring that there's good communication with respect to any of those kinds of changes. We know, for example, from the GDPR about liability of a data controller and a data processor and how that works. So ensuring the contracts between data controllers and data processors have the right provisions and the right types of reporting and notice is a significant issue. Are the vendors required to follow the company's instructions about data processing? So again, I think it's just really about transparency and about making sure that both parties to the contract know exactly what's going on, what the requirements are of each side, and keeping each side, up to date about what's going on. Along the lines of what Jenny was saying, these things are somewhat of a moving target. If amendments need to be made to the contracts, making sure that there is a mechanism for doing that, and making sure that those types of agreements are reviewed periodically and signed off on. And then lastly, what kind of remedies are provided for if you have the unfortunate situation where a vendor fails to comply. We included the privacy by design principles, obviously sort of the underpinning of very much of our privacy laws, thoughts, best practices, and so on. As we're deploying or designing new systems, or our clients are, and we're adopting new systems, thinking about privacy as at the beginning of the process as opposed to an afterthought is critically important. So we just keep those principles in mind all the time as we go through this process, and something that if you can build it into the sort of the corporate culture, it will help, I think, quite a bit as we're in the environment we're in right now and where we're probably going to be. So with that, I think I'm going to turn it over to Jenny.
Thanks, Marty. So what I'm going to focus on is what are the privacy and security issues that sometimes arise when employees have less direct oversight. And while we're moving to the slide, just to touch on what Marty was talking about with the vendor agreements, I think this also comes up in that context, because you now have your vendors that are also having employees that are working remotely. And again, there's less oversight. So it's something you might want to look back at the agreements and see if there's any terms that need to be adjusted, or perhaps additional restrictions that should be put into place with respect to those vendor agreements in light of the work from home situation. And then the issues that we're going to talk about on this slide also apply both within your organization as well as any outside business associates that you might have that are doing work for your organization. And these are things like, so when you think about hacks, you can have a hack that's done by a third party, but then you can also have breaches that occur from inside the organization. And a lot of times these are overlooked. And in light of the current work from home situation, and particularly the rush effort to get everyone working from home, this is something that when you have time, you should sit back and evaluate. And there's kind of different categories of people. So there's the malicious insider, and this is someone who might be a perturbed employee and is trying to hurt the organization. And they, key things that you want to look for are times of access, large data transfers, maybe they are visiting the premises when most employees are not. And you can have policies in place to try to limit this. And if they're breaching the policy, that could be important. So think about the legal restrictions and the legal policies that you want to have in place to protect against malicious insiders. Next is the negligent insider. And so this is someone who has legitimate credentials. They're a trusted employee, but maybe they're sidetracked in view of all that's going on. They might be trying to do their job and, homeschool their children and everything else at the same time, and they just breach a duty. And so, important things here might be encryption and, maybe two-factor authentication or restrictions on who has access to what. And so again, it's revisiting the policies, and maybe you want additional policies in place in view of work from home to prevent these negligent situations. And then there's the accident. And so what Marty was talking about with training is really important here, because usually the accident occurs when someone just doesn't know, and maybe they click on a link and there's phishing. Phishing occurs because they click on the wrong link, or they malware is installed and suddenly an outsider has access to the entire network. And so the biggest way to prevent an accidental breach is by training. And then there's the mole, who's the outsider who gains access, and obviously reasonable security measures, two-factor authentication, alerts, all of that is important. We'll go to the next slide. Oh, actually, I think we have a polling question on this.
Yes, I'll go ahead and launch that, Jenny.
Okay, has your company ever experienced a data breach? And if you could just take a few minutes.
All right, we'll give everybody about 10 more seconds.
Wow, this is interesting.
All right, I'll go ahead and close the poll just for purposes of time here.
Okay, I found it fascinating watching the numbers change, and it was particularly interesting, I think, is that the numbers for the insider threat are higher, or as the results were coming in, it looked like kind of it was going back and forth, but it's about the same as an outsider. And then obviously you have 12% that's both an insider and an outsider. So I think this just goes to show how important it is that there are corporate policies in place that allow you to, to monitor employees and to restrict employees, and that you don't feel protected from within your organization, and you're only trying to prevent breaches from outside, because I think the focus always tends to be on the outsiders and not the insiders. So next, we're going to talk about some compliance issues that happen when employers are sidetracked. And what we mean here is simply that in view of COVID-19, a lot of employers have had a lot to deal with, obviously. And so maybe compliance with new privacy legislation hasn't been top of mind. And what can you do to try to be as compliant as possible, given that you have a lot going on and that you have a lot of your workforce potentially working outside of a physical office space, which might make it hard. And on this, I would recommend everyone check out a manual that we have on our website. It's called Spring Cleaning While You Are Housebound. And it's kind of a fun approach to getting your data in order and becoming compliant. We have some good pictures and just kind of fun ways to look at it. If you can make privacy and data protection fun, we did it. The big question is if. But we go through steps, and like data mapping is something that should be very easy to do from remote. And it's a good opportunity if people are remote and you're trying to figure out what can we do now versus save for later. Data mapping should be top of list. Get your data in order, and then accessing your privacy framework. And this is things like looking at the laws that apply, looking at third-party contracts that might apply, and kind of along with that, you can see not just what regulations there are in those contracts or laws, but also perhaps you want to update the contract. So it's sort of a review that might have multiple goals. Back-end system changes might be a little bit more difficult to do remotely, but we have some suggestions. And then obviously you want to update your policies as you make changes and as you review things to make sure that you are communicating to others exactly what the practices and policies of the organization are. So next, we're going to talk about some back to work measures. And so different organizations are at different stages, depending on your size and your location, on where you are on opening back up. But eventually all of us are going to have to deal with this big question. And so, you know, the question is, what do you do? You know, there's employment lawyers who might tell you if you should do temperature checks or if you should do questionnaires on travel or on symptoms, contact with other people. What we're here to advise on and to discuss is, what do you do with the data that comes from that? So say you know, ask people about temperatures, you do a temperature check, or you ask about travel, and you get all of that information. What do you do with it? If we could go to the next slide. So here's sort of a framework on how we think is the best way to analyze what to do with the data that comes from it. And the first category is data collection and use. And here you will be determining what data you'll use. So maybe a lot of it you won't keep at all. You know, if somebody doesn't have a fever, maybe you just throw all that out. Data minimization is a very important policy, and it's something to try to practice. And then you want to determine what buckets you do want to keep. You know, maybe you do want to keep fever, but then if you are keeping it, you want to know why. Are you keeping that data because you have to under a law? Or are you keeping that data because you want to be able to protect the organization in the event of a litigation or, you know, a challenge that they didn't have adequate safeguards in place? And if you're keeping it, how long do you want to keep it? So that's a very important thing to have a plan for, and to not just keep data because you don't have a plan in place. And then this gets into the data life cycle. And this, you know, again, how long you're keeping it and with whom the data is shared. And this gets to the issues of, you know, insiders having access to the wrong data. You don't want everyone in the organization having access to everyone's health data, for example. And then finally is security and access considerations. And this is, for example, if an employee can request information on, you know, what data the organization has kept with respect to their, you know, the COVID tracing or temperatures and stuff. And then as well as protections on how the data is stored and who has control over the data within the organization. And these next two slides just kind of map out exactly what I was talking about. So here's some examples of questions that might be asked. If yes, record the data, and then what are the next steps? So we can just click through this. And this same thing, the important thing on this slide is just that little star, orange star on the side that's reminding you to make sure that your policy aligns up with your practice. And then finally, there's surveillance measures, and I'll try to get through this quickly in the interest of being able to answer some questions. But you might be doing video surveillance to try to, for example, enforce social distancing, or perhaps for infrared technology to check temperatures. And if you're doing that, make sure to check. In the United States, there are state laws on video surveillance and, for example, the right to have hidden cameras versus, you know, having to disclose the cameras. And there are restrictions on video cameras if employees have an expectation of privacy, for example, in like a bathroom. And then the next slide, we'll talk about the recording audio as well. So a lot of times when you have a video camera, you just kind of assume, oh yeah, we'll capture audio also. But the state laws in the United States are actually much more stringent on audio recordings. And so you want to check with that. And then there's a federal law on wiretapping that could apply as well.
So really quickly, just a couple more slides on how to address data protection and trade secrets when you have furloughed or laid off workers, as we've seen a lot of kind of this summer with COVID. So of course, pre-termination, when the employee is still with the company, communication is really key. So you want to let employees know exactly what information is considered confidential, whether that's physical physical markings on the papers, limiting access to only certain employees who can access that data, and even considering non-compete covenants. So you just want to be crystal clear as to what is a trade secret and what's kept confidential in your company. And then at termination, when you're doing your exit interview, you just want to remind them of these obligations and continued confidentiality, the need for that, even when they go to another employer. So with this, you might want to consider a severance package or a type of separability agreement where, you know, in exchange for maybe a monetary value or 1 month's more pay, that they might sign off on continuing to keep certain information confidential. And of course, you want to retrieve any used devices that the company, that the employees used for their employment at the company, and any information that might be stored on their personal devices as well. And just kind of monitoring this, you know, if you have somebody who goes across the street to a direct competitor, just keeping an eye on if they're complying and being complying with those kind of confidentiality obligations. So yeah, just a couple slides. We do have a privacy blog if you want to keep up on new laws, cases, regulations kind of in the privacy and data protection cybersecurity area. So definitely check us out at theprivacylaw.com. And then we've also included a couple of additional resources here, some other presentations and publications that members of our privacy team have done as well. So I think at this time, if we have time, maybe I'll pass it back to Marty and we can open it up for some questions.
Sure. Yeah, there's a number of questions that have come through, which I was looking at. One of them I thought very interesting as I'm staring at my Alexa device, which is muted. What are your thoughts on the Internet of Things for home working employees? I rarely see smart devices included in cybersecurity policies, i.e. the listening devices in our home, such as Alexa or Google Home devices. Do you think that employers should be concerned about this? And how do you suggest that they address this issue? I mean, I think it's a really important consideration. I think it's obviously much more important now that we're all, you know, many of us are working from home. I think that the organization should have a policy associated with it. We were talking before. I mean, these cybersecurity policies and things like this, you can have restrictions that you want to put in place from a legal standpoint that protects the organization, but to me, you know, and I try and be a practical lawyer, how practical is it that, you know, you're going to be able to really get the employee to do the things that are in your policy? And so you're sort of balancing, you know, those two things. But I often, you know, when I'm having a video conference or whatever, am looking around and, you know, I see my Alexa device there, and, you know, presumably, you know, it's not listening to me, but it's a really great question and a really valid consideration. And I think something that should be addressed in a cybersecurity policy now more than ever. I don't know if you guys want to add to that.
I completely agree. I mean, every now and then I'll have my cell phone sitting on the side, and this applies if I'm at work or if I'm working from home. But all of a sudden Siri will come on and say she's looking into something, and, you know, you're like, oh my goodness. But it is something that, you know, that should be considered. Just like companies are putting restrictions on using Zoom, I think that it's not, you know, out of the realm of consideration to also have restrictions on what third-party devices could be listening in.
Yeah, I think it's important to address it. Another great question. When the workplace is the employee's home, is there still no right to privacy? Do you see this rule evolving given the shift to work from home? I mean, I guess the way I assess it is there is no right to privacy relative to, you know, kind of when you're on the clock and when you're using the employer's equipment, you know, software, laptop. I mean, you may be using remote access on your personal equipment, but I think that you are implicitly, if not expressly, in a policy employment agreement, sort of giving up your right to privacy, not to your entire home, but to the workspace when you're on the clock. I don't know if you guys think any differently.
I agree. I mean, I think to the extent more states adopt general privacy legislation, and if a federal privacy law ever comes out in the United States, that would obviously apply, universally. And so that could give employees more of a right to privacy. But I'm not aware of any pending legislation that's dealing particularly with the work from home situation.
I agree. I think there needs to be somewhat of a balance, and what Marty was saying with, just like the practical considerations. I think it's, a lot of companies can't afford to give all employees a company laptop to work out from home or a company cell phone. So I think it's kind of a balance of accessing your work stuff on your personal devices. So, there's some pros and cons and gives and takes with, with the privacy implications there.
The one piece I would add, just as a litigator, is even if you are using a personal device, be very careful as an employee to limit kind of the scope of how you use that personal device. It's one thing if you're using your personal device to VPN into a network, but then don't start using your Gmail, your personal Gmail, or Yahoo Mail or whatever to do work, because the more you open up your personal life to work, then when issues arise and there's litigation and discovery, then suddenly your personal life becomes, what gets scooped up in the buckets of discovery that's considered, and you don't want that.
I think we probably have time for one more. Another interesting question. I think it's interesting. If a subject submits a data access request, can they obtain information pulled together as part of an investigation into the subject's alleged wrongdoing? Do you all have thoughts about that?
My thought is that is probably more of an employment law question, unless it has to do particularly with like personally identifiable information. But I don't think, that the data subject request that we're talking about and that we consider under like CCPA, for example, that's dealing with the personally identifiable information, not something like some sort of delinquent employee issue.
Yeah, I would think you'd be able to get the PII to the extent the employer is retaining that type of information, but not information about the alleged wrongdoing. It's a neat idea to try and get at that information, but I don't know that you'd be able to do it. And I also would say you'd have to look at the terms of the employment agreement, if there is one.
Absolutely.
I think we've gone a few minutes over. So with that, thank you all for your attention. We hope it was helpful, and please check out the blog and the other resources.
Feel free to send us an email if you have other questions.
Yes.
Absolutely. Thanks all.